Good afternoon. It is Wednesday, July 30, or July. Oh, if dreams. That's the second mistake this year, delegate card. That's number two. That's number two. My unblemished record. Oh, well. It's Wednesday, January 31st, 2024, and this is the House Judiciary Committee. We have a number of different bills. Delegate Chang, come on up. We'll get your bill started now. House Bill 259. Just a note for the committee. House Bill 664 is the Judicial Security Bill. We are going to start that bill 30 minutes after the completion of the JPR hearing, no matter what. So when they finish over there, they're going to make their way over, take some time for themselves, and then we're going to just take that hearing whenever that is. So for everybody else, we're going to try and get through as many of these bills as we can prior to that. And then if we don't finish all of it before that, we'll get to them after they're done. So with that, Delegate Chang, that's great. And is this Mr. Phillips?
Yes, sir.
All right, wonderful. Delegate Chang, you have 3 minutes. Go ahead.
Great. Thank you very much, Mr. Chairman, Madam Vice Chair, members of the House Judiciary Committee. I'm Mark Chang, member of Maryland General Assembly, District 32. This afternoon, presenting to the committee House Bill 259. What the bill does, it increases the current motor vehicle violation fee from $7.50 to $10. And the $10 amendment has been disseminated to the committee. And the reason why is because we decided to round up based on feedback that we received from the district court system, just to make things a little easier with the rounding. But the part of the reason why we're seeking to increase these violation fees is to help with the Maryland Emergency Management Special Operation Fund. What that fund does is supports the trauma system and also our world-renowned emergency system in the state of Maryland. And for example, the University of Maryland Shock Trauma has a 98% success rate. That the most critically ill and injured, when they go to shock trauma, they have a 98% chance of going back home to their families. And that doesn't happen by accident. It happens because of the investments we make. And part of the ways that we're able to support those investments is through the motor vehicle violation fees. Forecasts show that the fund will be insolvent in years to come. And so now we're trying to do what we can to get ahead of the curve and be able to support long-term sustainability for the fund. That way we continue to have the best world-class trauma system, not just here in the nation, but across the globe. And really, state of Maryland, we're proud of many things, and our trauma system is one of those. And so ask the committee to please consider raising the motor vehicle violation fee from $7.50 to $10. Thank you very much for the committee's time and for a favorable report. Thank you.
Thank you, Mr. Chair. My name is Bob Phillips. I am the legislative chair for the Maryland State Firefighters Association. I'm here representing 25,000 volunteer firefighters and EMS rescue squad members across the state. Delegate Chang has actually told you a lot of stuff I was going to tell you. This fund increase is very much needed. The members of the MSOFT vary widely, but they all come together as partners. We talk about Maryland Fire Rescue Institute. They have a part of this fund, and they provide the training to all the volunteers across the state at no cost to the volunteers. You have Maryland Institute for Emergency Medical Systems. They have a part of this fund. They provide the certifications and the direction of our EMS services across the state. Maryland State Police Aviation Command, very integral part of this. They have the flight paramedics. They have the helicopters. They provide the air transport of serious trauma patients from a scene of an emergency into the shock trauma system in what has been termed the golden hour. These partners are all coming together. We have shock trauma. They have a part of this. And just maintaining their system and their unique skills, it's very expensive. And you have the AMOS 508 funds that provide money to the volunteers to keep their equipment, their firehouses, to keep their people ready to respond when there is a call. All these partners come together and they draw funds out of the MSOF fund, Maryland Emergency Services Operations Fund. As was spoken, the fund will be insolvent at the end of this year. And we need a favorable response and vote on this bill. I thank you very much.
Questions from the panel? Oh, Delegate Sample Hughes, go ahead.
Thank you, Mr. Chair, and thank you, Delegate Chang, for bringing the bill forward. I cannot say enough how important that this is. In 2017, when my son had to be airlifted, he was a fireman, to Baltimore. You're right, golden hour is exactly what it was. And so to that end, I know how important it is for this entire state to have those services. My question to you is, and you may have said it, but I just wanted to understand that if and when we approve this, is there long-term additional planning for other funding sources, or just really looking at it even beyond where we are with this potential increase?
Great. Thank you very much, Delegate, for the question, and listening to your question, just reflecting upon, remember when your son was saved through that system, our trauma system, and it's really just a testimony of an example how we do have a world's best system. There are many ways how the MEMSOL fund is supported. It's through registration fees and also through other revenue sources that we do receive through the different sources. And this is one of them. And the motor violation fee is one of the components. And as far as this bill goes, with regards to this sponsor, looked at ways to increase the motor vehicle violation fees to help support it. And part of it is that the data, there's different statistics available that a lot of the patients who arrive at our trauma systems or transported by the different medical emergency system network there, it's because of motor vehicle incidents. And so this is part of a way to hopefully help our drivers out there and those on the roads to be a little bit more conscious about, that we need to be careful out there on the roads, but also to help with supporting one of the drivers that affect our trauma system in our state. But yes, there are other components, and I think also there are other bills out there where they're looking at other sources to be able to increase those revenues. But this is a modest bill, and I started off with, I think it comes out about 25% increase, but this is just a start. There are many more ways for us to look at it, but I wanted to take a modest approach to at least try to help support this system that's near and dear to all our hearts. And Delegate Sample Hughes, thank you very much for reminding this committee and all of us about the system that we do have.
Sure. Thank you, Delegate.
Thank you. And thank you also for bringing it. I just want to make sure the fiscal note assumes that this increase will go entirely to MEMSOP. Is that also your intention?
Yes,
that the
ma'am.
other amounts will stay flat?
Yes, ma'am. You up all the funds. I believe it's about $275,000 to $300,000 that the fund would be more sustainable, that the increase the fees will go to the MEMSOL fund specifically. Yes.
Thank you.
Delegate Kaufman.
Yes, I just want you to reiterate for the record, how long has it been since the fund was increased from $7.50 to $10? And I'm sorry, $9.50 to $10. I misheard you. Can you just reiterate for the record also how big the shortfall is in the trauma fund?
Yes, as far as the last time that the rates or the fee was increased, it's probably approximately about a decade or so, and we're looking as far as the insolvency being like tens of millions of dollars. So those are the initial forecast projections, and again, it's the reason why we have the high success rate is because of those investments that we do make, and we want to continue to have this as a long-term sustainable program that this body helped establish years ago and has really saved countless lives across our state.
Okay. Brief follow-up, Mr. Chair, if I may. So it's been 10 years, and I just want to make a point. This fee is not chained to inflation, is that correct? So it's probably in real dollars, bringing in less each year. Is that correct? That it's
Sure,
not changed
yes.
to inflation?
Thank you very much, Delegate Kaufman. Yes. And again, if the committee, as the committee goes through the deliberation process, if they are looking at other ways to have more of a modest, an increase to this initial modest proposal, I think that'd be a good start too, in looking at that.
Thank you, Vice Chair Chang. Very critical work.
Thank you.
So this fee is something that is assessed on somebody who gets a speeding ticket, is that right? A
Yes.
DUI, they
Correct.
break some kind of traffic law, is that
Yes,
right?
yes, Mr. Chairman. It wouldn't apply to red light cameras or speed cameras, but
Right.
those incidents that you've just mentioned.
Not red light cameras, none of that,
No.
just this.
Correct. The
Okay.
moving violation, yes.
All right. Thank you very much. The Vice Chair.
Thank you, Mr. Chair, and thank you, Vice Chair Chang, for bringing this bill. I believe we have two young future leaders, future legislators, possibly even future firefighters who are here with you today. Do you mind introducing them?
Sure, if the two
Or if
gentle
they could
ladies-
stand up.
Sure, if they could stand up, they are for both from Chesapeake Science Point School and a charter school in Hanover, Maryland, and in Hanover, Internal County, so.
Right, in District 32.
In District 32.
Thank
Thank
you
you.
very much.
Thank
And
you,
thank you,
Madam Vice
Mr. Chair. Isn't that so?
Okay. All right. Any other questions? Seeing none. Thank you very much.
Thank you very much. Have a
Delegate
great afternoon.
All right, that concludes the testimony on House Bill 259. We're now going to Delegate Cardin and House Bill 324, and you're going to bring people up or not? Roland Schrabler. I did stick the landing on the name.
That's
All
very
right.
rare, but I appreciate it.
All right,
Members of
House-
the committee,
Bill 324, go ahead.
thank you, Mr. Chair, members of the committee. For the record, John Carden on behalf of House Bill 324, asking for your favorable report. This is a piece of legislation that came from the States and Trust section of the Maryland State Bar Association. And I will defer any technical questions to the State Bar represented here by the gentleman to your right, my left. Just very briefly, the Uniform Transfer to Minors Act allows for the benefit of the minor, allows an estate to be able to, the administrator of an estate to be able to transfer money to the minor. If the minor has a guardian, that guardian is required to make certain filings. However, if the minor only has a custodian, if there's a custodian who's caring for the best interest of the minor, a custodian has a lesser degree of oversight. In 1989, we increased the amount that could be transferred to a custodian to $10,000. And if you change it for the rate of inflation and think about the 25 years that have come since 1989, it is appropriate for us to be able to transfer more money to that custodian for the benefit of that minor. And that's what this bill does. It increases it. You will note, if you actually read the bill, it's a very short bill. It's one word. It's just like one number. It changes it from 10,000 to 50,000. However, given both the rate of inflation and some degree of conversations in the Senate and here, there has been an agreement among the bar and all the members that it should be increased to 25,000, which is the appropriate amount, and not 50,000. I have an amendment in drafting to do that. It will be commensurate with what's in the Senate. I would ask you guys to vote on this favorably.
Thank you. Good afternoon, Mr. Speaker and members of the committee. My name is Roland Schrabler. Sorry,
The Vice Chair was
Mr.
chair
Chairman.
yesterday, so I guess
Mr.
that's
Chairman.
what's going to happen. I don't know.
my apologies.
Don't tell the speaker. Okay.
Thank you. No. So as Delegate Cardin explained, in 1989, the amount which can be transferred to custodian on behalf of a minor was set at $10,000. It remains there. It has remained there for 35 years. The bar would like that amount to be increased to 25,000. And this is important because if one either needs to petition to have a guardian appointed or to petition the court to pay an amount over $10,000 to a custodian, then that costs legal fees, takes time and effort, and those legal fees would eat into the funds that are supposed to be there for the minor, are important to the minor. And for that reason, we're seeking this increase to 25,000, and we would ask that the committee issue a favorable report on this bill.
Mr. Chair, there's no opposition as far as we know.
Okay, but yet Delegate Phillips. Delegate Phillips, please.
No, and
Speaker Phillips.
sorry about that, Mr. Chair, but this is an area that I'm very interested in. So could you walk us through when this would apply as opposed to just having a guardianship appointment either for the attorney or for another family member, or et cetera?
Sure. Thank you for your question. This would apply in situations either where there is no will or where the will does not contain a specific authorization for the personal representative to pay any larger amount to a custodian. And then there would be a minor beneficiary of this estate whose share of the estate totals more than $10,000. If it's under $10,000, then current law would allow it just to be paid without any further action to a custodian who would safeguard those funds for the minor. We would like that amount to be increased to 25,000, commensurate with inflation. And as stated, if it's currently say $11,000, then the personal representative of the estate can either then start eating into those funds by paying someone or figuring out on their own how to petition the court for authorization to pay a larger amount, or how to petition the court for the appointment of a guardian.
I got it. Okay. All right. Then why not more? Because you think the fees would be approximately that?
Because of the inflation adjustment, and also because a custodian safeguarding the funds for the minor has less oversight than a guardian would. So one wants to set the amount properly so that it's efficient, but also so that it is not such a large amount that a custodian would be holding with little supervision over. So 100,000 wouldn't be necessarily appropriate because the custodian doesn't have a lot of reporting requirements. And at that dollar amount, you're better off having a court looking into, in a guardianship sense, where is that money? How is it being spent?
And so there is no annual reporting for the custodian, but the guardian there would be. So can I ask this last question? Orphans court judges are good with this.
The orphans court judges, we discussed this with them, and they, in that discussion, the change from $50,000, our initial wish from a practitioner standpoint, was adjusted down to 25,000, which they are good with.
Okay.
I don't want to speak on their behalf, but that's our discussion.
And we did not get any testimony from them, I think, for that reason, because of the agreement for 25,000.
Got it. Thank you, Mr. Chair. Speaker.
Thank you, Mr. Chairman. There's a lot of legal talk there. In layman's terms, could this potentially, exactly. Could this potentially be used to pay for like medical expenses for the minor?
Correct. The funds, whether paid to the custodian or paid to the guardian, are there for the minor's benefit, whether it's medical, whether it's education, whether it's appropriate school supplies, all of those types of things. So when there's the potential, at least, that you have to hire an attorney to file these extra petitions, that means there's going to be less there for the minor who frequently really needs those funds for all of these needs: health, school supplies, education, whatever it may be.
Thank you. That was the one thing missing in your explanation to the delegate next to me.
Are there other questions for the panel? Seeing none, thank you both very, very much. Thank you for joining us today. That concludes the testimony on House Bill 321. Now going to Delegate Grammer and House Bill 137. I think it's just two people testifying, Delegate Grammer and Keisha Goodwin. Great. Everybody else, I think, is, yes, written. Okay. So we'll hear from you. Go ahead.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 137. House Bill 137 provides limited protection to teachers or staff members of a school for personal injury or property damage resulting from intervention in a student altercation or other student disturbance on a limited basis. Many jurisdictions have problems with the retention of teachers. I know Baltimore County does. If you speak with teachers, they express frustrations with concerns in the classroom. Teachers often report that they feel pinched by expectations of the school system while feeling unequipped to handle the issues that they encounter. Frequently, this disconnect drives teachers or staff members from work in education. And indeed, while county boards of education must provide legal counsel to a teacher for an intervening individual, there are no actual protections for a teacher who acts in good faith. So what this bill does is it offers a narrow protection for teachers or staff who act to protect a student who is in danger or who acts to de-escalate a violent situation, as long as that teacher or staff member acts in a prudent manner, and as long as that actions taken do not constitute grossly negligent, willful, wanton, or intentionally tortious conduct. I feel that with this simple change, we can provide significant protections for good actors who act in defense of their students and take personal risk to de-escalate violent situations. The bill's in the same posture as it was when it last moved from the House. I'd be happy to take questions, and it asks for a favorable on House Bill 137.
And remarkably, it had the same bill number last year.
I know. Can you believe that?
That is really unusual.
Made the testimony great.
Okay, well, just bring it all back. All right, that's right. All right, I'm sorry now. We're gonna live in that. All right. Yes, Goodwin, please.
All right. I'm Keisha Goodwin, and I'm representing the Baltimore Teachers Union. The Baltimore Teachers Union supports HB 137 legislation that will protect administrative, educational, and support staff from civil liability from personal injury or property damage claims that may arise from their response to altercations and attempt to keep children safe. The Baltimore Teachers Union represents 8,800 teachers, paraprofessionals, counselors, clinicians, librarians, secretaries, community school site specialists, bus transportation aides, and many more school-based and central office support staff. We are 4 out of 5 workers in Baltimore City Public Schools, serving 75,811 students and their families. Our national union, the American Federation of Teachers, has over 1.7 million members in the United States and in its territories. HB 137 provides that a member of the administrative, educational, and support staff on any public, private, or parochial school acting in an official capacity is immune from civil liability for any personal injury or property damage resulting from an intervention in an altercation between students or other students' disturbance. If, number 1, the member intervened in a reasonable, prudent manner, and number 2, the actions taken by the member and intervening do not constitute grossly negligence, willful, wanton, or intentional torturous conduct. This bill recognizes the challenges faced by school staff and aims to provide the necessary protection against civil liability when they act in good faith to prevent harm and maintain a secure learning environment. By offering civil immunity, we empower our educators to take prompt and necessary action without the constant worry of legal consequences, fostering a safer and more secure educational setting. Moreover, this legislation is a testament to the acknowledgement of the unique and challenging nature of the work performed by school staff. It reinforces the importance of supporting those who are dedicated their lives to the education and well-being of our students. The proposed civil immunity protection is not only a measure to shield our educators from unjust legal repercussions, but to recognize that the commitment they have to the safety and welfare of our students. The
Okay.
Baltimore Teachers Union urges a favorable report on House Bill
All right,
137.
thank you very much. Other questions? Delegate Kaufman.
Yes, as my mother will tell you, Delegate Grammer, I've always beaten to my own drummer and been an independent thinker. As such, I was the only member of the House of Delegates to oppose your bill last year.
This is a terrible start. I'm just kidding.
Very good. Well, my question is, because I hate to close the courthouse doors on individuals. So that's why I opposed it. And so you say prudent, which I appreciate, but I looked at the legislation and it doesn't appear that prudent is defined in the bill. So my prudent could be your imprudent. So a parent could think that, hey, that the teacher could say, the shove that accidentally, damaged my kid's rotator cuff was necessary to break up a fight. And the family or the kid could think it was imprudent, because they could have broken it up another way. So how do we determine what's prudent? And secondly, if we pass your bill, are you, maybe not given our ideological differences, but are you at all concerned that this next special group of people will give us civil immunity too?
So I believe the bill actually has prudent in it.
Yes.
Could you read? It's not defined. So I asked who's going to be the arbiter in determining what's prudent and what's imprudent?
So that would be the finding of the facts, if I believe. But I will say in the first year that this bill was brought, the Institute for Justice actually came in with an amendment to clarify the exact thing that you're speaking about today. And they wanted to really limit the applicability of the law to really those cases where, they didn't want to have a giant gap of immunity. So what they did is they really came to us with an amendment that really narrowed it down to the situations and circumstances where a teacher or staff member, bus driver would be acting in good faith. So I believe, I'd be happy to send you their communication, but I believe we've really nailed it in regard to the applicability of the law.
Thank you. And I would appreciate reading that communication. Just to follow up with my second question, though, that I asked you is, are you concerned about the precedent that this would set, that another interest group will come and say, well, I'm a sanitation worker and I want immunity too, or I'm a this or I'm a that?
Yeah, that's an interesting question. There's every bill I sponsor, there's always a story and there's always someone that comes to us with a real need. And maybe we should redirect that to the young lady who can comment on the need to have protections for teachers and staff members. You want to take that?
Sure. So currently, there are plenty of altercations that are happening in the classrooms, and it's making it dangerous for students and staff. And currently, if you just try to break it up and you accidentally a fingernail scratch a student, then whoever that staff member is held in some type of constraint or something by administration, or have to leave work or whatever the case may be until they finish the investigation. And so this has caused staff members to not intervene. And By the time you call the office and wait for somebody to come to the classroom to help intervene in an altercation or fight that is happening in the classroom or in the cafeteria, more damage and injuries has occurred to the students than it could have had the adult in that place been able to try to intervene before calling the school resource officer and such. And then you have parents that complain and say, well, it was adults there. Why didn't they step in and do something before my child got this and before my child this and that happened? So it's a catch-22 that staff are in the middle of right now.
And the really germane part of her story is something we hear frequently. It's that it causes the teacher to not intervene, or it causes them to pause and say, well, I see that this kid is smashing another kid with a chair, but am I going to get caught up in the system? Am I going to be held liable? And, you know, teachers aren't first responders. First responders always jump to protect somebody. But there are circumstances where you know, teachers really want to step in and protect a student who is really in harm's way.
Delegate Tomlinson.
Thank you, Chair. This is an interesting bill. I've got something similar I'm going to be dropping, but I'm not here to plug my own bill. And it's timely. I just had a constituent send me a video of a fight that happened in one of the high schools in my district, where a kid goes through a sink. Actually, and he got back up and continued the fight. But there is I believe it was maybe a junior ROTC and an administrator. He was wearing a suit. It looked like he was probably a principal of some sorts. And they don't break up the fight. They're just giving comment. They're just saying, hey guys, break it up, as a kid's going through a sink. So my question to you is, do you think students know that they can, are they aware that the administrators are hesitant to break up the fight?
Yes, they are, because it's a common practice. If a child say, like the delegate said, you pushed me too hard, or you grabbed this child first before you grabbed this child, they are aware that teachers and administration receive consequences if they try to break it up, and if they complain that something has happened during the incident of trying to diffuse the altercation. So yes, they are very aware, and so that's another reason why you see so many altercations and fights.
And keep in mind, the baseline advice given to teachers by the board frequently is don't intervene.
Yeah. So do you think if students, maybe it would take a couple years, or maybe take a couple fights getting broken, if your bill passes and more teachers were starting to break up fights, do you think that could lead to maybe less altercations if they know they're not going to be able to have a full out 3-minute brawl?
I think it'd be a deterrent.
Okay, thank you.
My mother was a teacher in Baltimore City Public Schools for about 30 years. And the thing that actually drove her out of the profession was an incident in which she attempted to break up a fight. And what resulted is that the student made a claim. And my mother went through this administrative process, kind of broke her heart, and it was the reason why she decided to retire. But having said that, so there are a couple of things that I see here. One is policy, and will passing this law potentially impact policy where city schools, Baltimore County schools, schools in general say to educators not to get involved? Is that correct? Am I correct by saying that? Is it policy?
Yes, for the most part, it is policy, and it is also advice from the union lawyer, because of the cases that actually have been thrown out when parents have said, oh, my child was scratched, or this or that has occurred, an investigation took place, a thorough investigation, and it was that 9 times out of 10 was not the case. So yes. And so if the policy changed, there will be education around the change in the policy as well.
And do you think it's because I'm also concerned about the teachers? So if we provide this, I'm concerned that we would then expect teachers to engage. And I'm not sure that that's what we want either. So how do we address that?
I believe there should be, the same way there's some type of progressive discipline for attendance for staff or whatever the case may be, there can be a progressive guidance on when to intervene or what steps to take first. First call the office, wait for the climate culture team to come. Look, just be observant of the severity of the situation, if whether or not you need to engage or not. So I believe clear guidance around it would definitely help to know when to intervene and when not, that gray area.
And I think the answer to that, which I like most, is that you and I won't have to figure that out. That'll be up to our local boards of education, and they will form the guidance around that. And that will be heavily deliberated by both teacher input, parent input, school input, board member input.
Okay, thank you.
Thank you.
There are further questions for this panel? All right, seeing none, thank you very much. That concludes the testimony on House Bill 137. Okay, they are still going on the judicial bill across the street. So, but one of the vice chair's witnesses, vice chair, one of your witnesses is Judge Morrissey, who is also over there. Delegate Munoz, you're missing two people too? I'm not sure. I mean, we might be taking. I live in quiet terror of this moment, but this is oh, your only witnesses, Judge Morrissey.
Right. But you know what? I can still do it. I can do it.
Do you want to do it? All right, so yes, she can do it. House Bill 315. All right, so we're gonna hear from the vice chair and that'll be fine. It'll be wonderful. Experience for us all. All right, House Bill 315.
Thank you, Mr. Chair. I know. For the record, Sandy Bartlett, Anne Arundel County, District 32. So I just wanted to let you all know a little bit of history here. In 2023, with the passage of House Bill 824, there was an amendment very late in the hour that would require the Maryland State Commission on Criminal Sentencing Policy the task of collecting certain data and compiling it with respect to gun crimes. Well, we've later learned that the commission does not actually have that capacity to do that assignment. We've also, so in the bill, as you have seen it, it says that the Maryland State Police is going to do it. However, we've learned that the best entity is the judiciary. So I have an amendment. It states that it's on your floor system. However, I didn't see it on mine. So hopefully it will be available. But I will tell you that the amendment is simply stating that it will be the Maryland judiciary. I wouldn't presume to speak for Chief Judge Morrissey. However, I would say that he would be able to go into details as to, first, yes, it is something that they're capable of doing. And if he wanted to, he could go into details as to what the process is in doing so. However, just to let you all know that we have talked to all the stakeholders and everyone's on board with judiciary handling it. That concludes my testimony.
All right, members of the committee, if you should happen to have a question for Judge Morrissey, he will be here in a little bit, but we're going to go ahead and do this part of the hearing. We may recall this bill just to make OIS's life a little more interesting in a few minutes after the judicial security bill. So we'll do that. Delegate Williams.
I mean, I don't need, it's sort of a question, but I guess sort of maybe I should wait for Judge Morrissey because I saw that he had signed up to testify favorable with the amendment. So was that the reason, the amendment you just mentioned,
Yes.
Delegate Bartlett?
Yes, the amendment is to include to make it for judiciary to be the task manager of to manage the tasks that we have assigned.
Okay.
Yeah.
Thanks.
Are there any other questions? Seeing none. That concludes the testimony on House Bill 315. How about now? You have everyone you can have. All right, we're going to hear House Bill 304, Delegate Munoz. Several people are virtual. So we'll get them to come in. Mr. Shire, come on up. Mark Panak, and I think Steve Kroll's across the street. All right, that's your person who's across the street. So we also have John Jocelyn, Kathy Wright. Okay. All right, so we'll hear from you, Delegate Munoz. Go ahead.
Like I'll get like the whole internet, like T-Mobile Verizon.
Thank you so much, Mr. Chair. Good afternoon, Judiciary Committee colleagues. For the record, I am Delegate Rachel Munoz, and I come today to humbly present to you House Bill 304, the Gun Theft Felony Act of 2024. Now, to some of you who've been here a while, I may sound a bit like a broken record today. This bill was first introduced in 2018. But I promise you, for the people who are new, this is an oldie, but a goodie. I have been in this committee long enough now to know that the F word is a bad word here. Felony. Every year Sorry, guys. Every year, an unknown number of Marylanders are killed or seriously injured by stolen guns. So let that sink in for a minute. We're talking here in this bill about stolen guns. Not legally owned guns, guns that were stolen and can then be used to commit a crime of violence.
We all got cell phones.
Mr. Mohammed, if you would please put yourself on mute. We'll get to you just in a moment. If everybody on the Zoom can put yourself on mute, we're getting some feedback and it's stopping us. All right, go ahead.
Thank you. We learned last session from State's Attorney Ivan Bates and the research of the United States Sentencing Commission that an increase in penalty directly correlates to a reduction in offenses. If you don't have that report from last session, please let me know and my office can get it over to you. As some of you may remember, last year I presented this bill before you all, a mere 2 weeks after my own husband was robbed at gunpoint in his pharmacy here in Annapolis, walking distance from this building. The man who robbed him with a loaded gun already had a criminal record and had no legal way of having the gun that he pointed at my husband that day. I will briefly remind you that under current Maryland law, the theft of a gun currently holds the same penalty as the theft of a bicycle, a handbag, or even a cell phone, a textbook, anything worth less than $1,500. States across the country, as close as Virginia and Pennsylvania, and as far away as Washington and even California, have already made the theft of a handgun a felony. It's time for Maryland to catch up. Just yesterday, we were all visited by the group Moms Demand Action. Well, as you all know, I am a mom of 5, and I'm here today to demand action. I appreciate your time and the opportunity to present this bill to you all. We do so much important work in this committee, but today I have a selfish request. Please do not make me come back next year and present to you the Gun Theft Felony Act of 2025. Let's work together to find a way to get stolen guns off our streets and hold dangerous criminals accountable so that every man, woman, and child in the state of Maryland can live, if even just a little bit safer. I respectfully request a favorable report on House Bill 304.
Thank you. Mr. Jocelyn. Looked down and saw Mr. Jocelyn and I meant, oh my God. Mr. Panak, I apologize.
Thank you, Mr. Chair. Mark Pennock, President of Maryland, shall issue. We enthusiastically and support this bill as we have in the past. So just to bring the committee up to date, right now, as of August 2023, there were roughly 159,000 carry permits in the state issued to law-abiding personnel. And they are often forced to store those firearms in their cars by legislation enacted by this body. Guns are stolen from cars. There's no incentive in this state, legal disincentive, to stop people from stealing those guns, breaking into the cars and stealing them. Guns are stolen from homes. Guns are stolen wherever they could be found. So we've enacted, this body has enacted strong protections for dealers designed to deter break-ins at dealers. This is a deterrence to breaking into people's homes and cars to prevent or at least communicate to the theft community, the thieves who inhabit this state, that it has real serious consequences if you steal a firearm. The word will get out on the street after a few people are made an example of and sentenced to serious time. There is really no earthly reason to punish the theft of a firearm, which is a crime gun, almost 100%. So leniently, like a theft of a TV. Almost all firearms that I know of, except for some very expensive ones, are worth less than $1,500. And that's how the current Maryland law treats a theft of a firearm, like a theft of a TV. I urge a favorable report.
Good afternoon. Mr. Chairman, thank you for allowing me to speak today on this legislation. My name is Mike Shire, representing the Maryland Fraternal Order of Police. Before I start with your indulgence, last week the Fraternal Order of Police, we lost our brother, our friend, Anne Arundel County Police Sergeant Eric Trumbauer. He served in the United States Marine Corps and for 21 years as an Anne Arundel County police officer. He was 49 years old and he left his wife and teenage daughter behind. And I would respectfully request a moment of silence in remembrance of Sergeant Trumbauer. Thank you all. I am here today in support of House Bill 304 on behalf of the Fraternal Order of Police. We all know that gun violence plagues our communities. Many of the firearms that are used in these crimes are stolen. This bill adds an important feature of deterrence and allows for true incapacitation for those who are stealing and channeling those stolen firearms into the hands of criminals who would harm our communities. As the gentleman mentioned, a stolen gun is destined to be used in another crime. This is not something that's being stolen so that they can personally enjoy it and fun and watch TV or do something entertaining with it. It is being stolen for a specific purpose, and that is to commit more crime and more violent crime. We strongly urge this committee to report favorably on House Bill 403. And as I said, the FOP stands in support of it. Thank you.
Now, Mr. Jocelyn.
Good afternoon, Mr. Chairman. John Jocelyn speaking for 2A Maryland in support of House Bill 304. To piggyback on what Mr. Pennock said, my vehicle was broken into several weeks ago. They did find the lockbox that I have in it. It was empty, but they still tried to get in. Nonetheless, the effort was made. They failed, but it does, reinforce what Mr. Pennock said. Once a firearm is stolen, it's in the crime realm. It will never come back out. Most of the firearms that are used in crimes are stolen. Since 1988, we have passed 32 gun-related bills, 28 of them gun control bills, all intended to make it more difficult for the law-abiding citizen to purchase, own, and use firearms. However, we've done nothing to address the fact that they are stolen and the penalties are far, far lower. In fact, this dichotomy makes it advantageous for the criminal to steal the firearm rather than try a straw purchase or build their own. We believe it is now time for this committee to step up and show us that they are serious about keeping firearms out of the hands of criminals by making the theft of a firearm a felony, as it should be. We strongly support this piece of legislation, and we hope that this is the year that you will join with us and pass this bill. Be prepared to answer any questions you might have.
Kathy Wright.
Thank you, Mr. Chair. I'm Kathy Wright, Vice President of Legislative Affairs for the Maryland State Rifle and Pistol Association. We strongly support House Bill 304. Gun thefts are a serious crime and a serious threat to public safety. If Maryland's leaders are serious about reducing violent crime, then our state should treat gun thefts as a serious crime, not a slap on the wrist. Governor Moore has made public safety a priority, and our state's attorneys, Aisha Braveboy and Ivan Bates, recently announced proposals they say will help curb violent crime. Ms. Braveboy said, quote, "The ultimate goal is not to lock everyone up forever. The ultimate goal is rehabilitation. But how can you have rehabilitation without accountability? That's what we're looking for," unquote. Theft of a firearm is considered a felony in many other states, including Idaho, Arizona, Ohio, Washington, and California. And in 2016, California voters approved Proposition 63 with more than 63%, which moved theft of a firearm from a misdemeanor to a felony. Less than $1,500, the monetary value of a firearm is irrelevant when it is in the hands of someone with evil intent. We need to be committed to ensuring that our state laws are tools used to deter crime and make criminals accountable for their actions. In previous years, similar bills have been proposed and received significant favorable testimony. The Maryland State Rifle and Pistol Association respectfully requests favorable report on HB 304. Thank you.
All right, questions to the panel. We'll start with
Mr.
Delegate
Chair.
Grammer, then Mr.
One more.
Kaufman. Oh, I'm sorry, he's back. That's sorry. We'll hear from Mr. Mohammed now, please. Mr. Mohammed, take yourself off mute. All right, and go ahead for 2 minutes, please.
Thank you, sir. Good afternoon. We definitely asked for support for this particular bill, Bill 304. This is a long overdue bill, and I'm glad to see that it's being presented again. A criminal who steals a $200 gun may commit as much mayhem as a criminal who steals a $2,000 gun. As Kathy just mentioned, that the value of that gun does not matter. That person can commit any crime that they want, regardless of the value of that gun. You have my written report, and I definitely ask that this bill receives a favorable report. Thank you.
All right, how about now? Delegate Grammer first, then Delegate Kaufman.
Thank you, Mr. Chair. Thanks for bringing the bill. We really appreciate it. Can someone from the panel talk about the percentage of crimes, violent crimes that are committed with stolen firearms versus a person who has purchased one legally?
Yeah, so
Go ahead.
I just have the FBI's stolen gun file has 2 million reports of 60% of them are rifles, and the 22% are handguns and 70% are shotguns. And so these are the illegal guns that are used in crimes, which is the majority. I believe it's 70 something percent. Yeah.
So the numbers I've seen on this, delegate, is that only about 2% of guns used in crime are actually purchased from FFLs, federal firearms licensees. So the legally purchased firearms are not the problem. It's the illegally acquired firearms, either through theft or otherwise, that are the problem.
Okay.
So this bill is zeroed in on that issue.
So that statistic kind of corroborates what the state police said last year. We've seen tens of thousands more permit holders in the state of Maryland. They haven't seen any issue with legal gun owners exercising their rights. That generally corroborates with what they said.
Well, that's true. And in fact, legal gun owners are greatly at risk because they become targets for theft. And the idea of this bill is to prevent, or at least deter, as much of that theft as possible. Nobody should think for a moment that people who commit firearms don't know they're committing a serious crime. And it should be more serious to make them at least think twice.
And I understand the first offense is not more than 6 months.
correct. And under the guidelines, sentencing guidelines, the recommendation is parole. And for the second offense, the guidelines say parole. So it's literally no punishment at all, which has no incentive for enforcement, either by the police or by the prosecutors, because there's no reason to devote resources to something when you know they're just going to get a slap on the wrist.
And therefore no deterrent.
No
Therefore,
deterrent.
no deterrent.
So we've debated the issue of gun ownership for the past several years. I know we talked about, we had the debate around home-built firearms, firearms that are not serialized. It's my understanding that the penalty for having an unserialized homemade firearm, just possession of an unserialized gun, was 5 years.
That's my recollection.
Yeah. So 5 years for just possessing a gun versus 6 months for stealing a gun.
Yes.
All right. Thank you so much.
Delegate Kaufman.
Chair, Ranking Member Munoz, this will surprise you and probably catch me flack, but I do like your bill a lot. My question though is, can you give me a little bit of a legal education? Because as I recall last year, as part of the chairman and my senator's bill, SB 1, Delegate Conway succeeded in getting tougher sanctions included in that bill for stolen guns, as I recall. He called it the Ivan Bates bill, and he did succeed in getting that in there. And so what I want to know, not being a lawyer, is since they're already, unless I'm hallucinating, we already succeeded in having stiffer penalties for gun thieves, what is the benefit of, to use your phrase, making it an F word, to make it a felony? What do you see? What was your rationale?
So the base bill, my recollection is the base bill increased the penalty from 3 to 5 years for carrying a firearm without regard to whether the firearm was otherwise illegal. So the base bill simply punishes the mere possession of a firearm, a handgun that is, outside the home and not falling into one of the exceptions of 4-203B. So that really doesn't bear, and as I recall, the SB 1 does not contain any increased penalties for stolen firearms at all. The chair can correct me on that, but I don't. My recollection is that it's not there.
So, Ranking Member Munoz or Mr. Penning, I'm just trying to comprehend. So what you would do is, I was correct to remember that there were stiffer sanctions that Delegate Conway got, but you would have stiffer sanctions for stealing, for actually the act of stealing the gun, because SB 1 is silent on that. So you believe there should be extra sanctions for the act of stealing the gun? I'm just trying to understand.
I do, Delegate. Thank you for the question. And I know I said this last year. I tried to be a little bit briefer this time. But my goal with this bill is not to actually put people in jail. It's not to put more people in jail for longer. My goal is simply to follow the research and the science that shows us that if we have greater penalties on a crime like this, we're going to see less of that crime. And so I'd like to see less stolen guns. I'd like to see less criminals in possession of guns where they can go and commit violent crimes against Marylanders.
Thank you, and thank you for your indulgence, colleagues, as I try to grasp this brave new world of law.
Thank you, Mr. Chair. Thank you guys for being here today. My question is for Mr. Shire. We've heard over the years that when we label something as a felony, it changes how the investigative resources would be distributed. Is that something that you've seen, and can you corroborate that?
Surely, you know, when we do label things as felony, that just brings it to the forefront, excuse me. And it often changes the court's jurisdiction as well, bringing it up to the circuit court realm as opposed to the district court, which also provides the prosecutors with more resources as far as prosecuting those crimes in that realm as opposed to the district court.
Okay, thank you. That sounds like a good move for us then.
Thank you.
Just to be clear, the penalty for the possession of an illegal firearm, or a stolen firearm, I should say, is 5 years, correct?
It is 5 years, but it is a misdemeanor. And I would not be
misdemeanor. So when it was said earlier that it only carries 6 months, that would be incorrect.
Oh, well, Yes, possession of a stolen firearm, that's correct. It's not the act of stealing. That's in 5-138.
How is it possible to steal something without possessing it?
Of course you must possess it, but what happens in the street is
So
that
that's the
these,
same penalty. It's 5 years, correct?
it's not a felony under 5-138, it's a misdemeanor. And what happens in the street is that once it's stolen, it's quickly sold. So it's very difficult to enforce the 5-138 penalty against someone who quickly sells it. Now, that's also punished by the 5-138, but it's a matter of deterring the act in the first place. Now, I would not be opposed to making 138, making that a felony as
So
well.
you would have supported the majority leader's bill last year that did exactly that.
I would have supported making possession of a stolen firearm a felony, yes.
That's what that bill did.
I don't
It's
recall
remarkable
that
the
I
number of people didn't support it last year.
I don't recall that I spoke in opposition to that.
The drug bill?
All right. I need to say
The drug
something
bill?
different and serious for a moment to respond to Lieutenant Shire and to speak to Sergeant Trumbauer, who is someone who I worked with in the Anne Arundel County State's Attorney's Office and who I believe, if my memory is correct, is the first person who I got to ride along with as a state's attorney in Anne Arundel County. I was very, very sad to hear of his passing, and I know that his family is struggling a great deal with that. And so, and on behalf of myself, I'd certainly want to send my condolences to the family, and I'll be doing that offline as well.
Thank you. We very much appreciate that. For those that didn't know, Sergeant Trumbauer, he was one of the leading DUI enforcers in the state of Maryland. He was a drug recognition expert and trainer. He was very well known in that community. And unfortunately, those that would drive under the influence are probably a little bit safer from arrest with his passing. So we will miss him greatly.
I will say that when I first started as a new prosecutor, he offered me helpful advice in the form of gentle chiding, several different cases to make sure that I was getting it right when I was questioning people about field sobriety tests. So
Very good.
I did appreciate his work and again, certainly send my condolences to his family.
Thank you, sir.
Seeing no further questions, that concludes the testimony for House Bill 304. There's no one else signed up to testify. We need a break. Are they still going in the Senate? Just finished. Here's what we're going to do. We're going to give the people who were testifying on the judicial security bill 30 minutes from right now. They're going to take a little break from being over at JPR and come across the street. Could we briefly, before all these students leave, could you identify what school you're from so that we can know?
CMIT.
I'm sorry?
CMIT North Charter School.
Okay. Where is it?
And
What did they say? Laurel, Maryland? Oh, very nice to see you. We're very happy that you're here. Upper Marlboro is the other location. All right. 2:30. All right, we are going to reconvene at 2:30 PM. We'll reconvene at 2:30 and we'll hear the final bill, House Bill 664. So we're recessed until 2:30.
Aaliyah brought them in. I don't know if they came to see you.
Members would please begin to take your seats, please. Members would take your seats. Delegate Taylor. You're in the middle. All right. We're recording. We are recording. Good afternoon, ladies and gentlemen. This is the House Judiciary Committee. It's Wednesday, the 31st. Okay. Wednesday, the 31st of January. This is our second portion, starting at about 2:30, where we're going to hear House Bill 664. I introduced the legislation on request and in support of the judiciary. We're going to hear a little unusually from the Senate sponsor. And we'll ask Senator Quarterman to come up to make a quick presentation. And then we're also going to hear from Stephanie Wilkinson, if she would please, is she here? If you would please come up to the table, that's fine. So we're going to hear from these two people first, and then we'll have a panel including the Chief Judge, Judge Badar, and Judge Salas, who are going to be there. We're going to basically invite you up next, and you'll have 15 minutes between all of you, and the judges can fight amongst themselves as to who gets to speak that long. All right, but for this, please, Senator Quarterman.
Well, thank you, Mr. Chair, and I do appreciate the opportunity here. I know it's, as you said, it's a little bit different, but I do appreciate the opportunity given this situation. So appreciate that. For the record, I'm Senator Paul Quarterman. I represent District 2, which is Washington, some of Frederick counties. Nearly 10 months ago, most of you may not be aware, but I sat on the floor or stood on the floor in the Senate and relayed the challenges and experiences that my family suffered through as my father, then a circuit court judge of Washington County, encountered multiple threats throughout his judicial career. Most notably, he was the recipient of 4 pipe bombs, 3 of which detonated, and they were sent to his residence. It is beyond comprehension how this type of targeted hate can be inflicted upon a specific group of public servants and their families, not only in the same state, but within the same local community. In October of 2023, the Washington County community, along with the state of Maryland, and most notably the Wilkinson family, suffered an unimaginable tragedy when Circuit Court Judge Andrew F. Wilkinson was murdered in the driveway of his own home. Left behind are his family, many of which are here today, along with his beloved wife, Stephanie, who joins us and their 2 children, Caroline and Grant. This vicious attack on a member of the Maryland Judiciary leaves an indelible mark on not only our local community, but throughout the entire state of Maryland and our country. As such, it warrants immediate action to protect not only the state's judicial officers, but also their families, and the hope that a similar incident can be avoided in the future. Members of the judiciary serve because they care deeply about their communities and our state, despite the additional safety risks to them and their families that are associated with their role. As legislators, again, it's our obligation to support legislation that protects both them and, again, more importantly, their families from these most harmful situations. These threats are real. They happen to real people. They've happened in our state, and they happen and affect the families of the judicial officers who serve the communities of our state. Again, Mr. Chair, I appreciate the opportunity here today. I appreciate the committee for allowing me this opportunity. We would request a favorable report, and I will let Ms. Wilkinson speak here. So thank you.
Good afternoon, Chair Clippinger and members of the House Judiciary Committee. My name is Stephanie Wilkinson, and I am the surviving spouse of Judge Andrew F. Wilkinson. We know that in July 2023, a defendant in a domestic case began searching for my husband on the internet. We also know that on October 19th, 2023, the man no longer had to search for Drew because the internet had easily led him to our home. While stalking our home, he was able to ambush my husband moments after he stepped outside to take a walk. I tried to tell myself that my husband did not suffer that night, but in reality, my heart is shattered when I think Drew's last feeling on earth was fear. Watch me closely. My husband was downed by one bullet, 1/4 of an inch off center to the left. And the stipling from the other bullet tells us it was a vengeful final blow. This was a close contact assassination by a disgruntled defendant who hated our judicial system and took it out on the judge in his case. My family is the victim of an attack on a cornerstone of our country, our judicial process. If we do not step in and offer our judiciary the protection and privacy they should have, we will surely water down the strength of the judicial system by getting less qualified candidates to fill those positions. There are companies out there like LexisNexis who have programs that can do specifically what we need. Please meet with those professionals and let them explain to you how they can help. In closing today, I am devastated that I lost my husband, but my heart is beyond repair that my children have lost their father. Please help make things right by supporting this bill. By doing so, you will assure my children and the children Drew saved in this domestic case that he did not die in vain. Thank you.
We thank you very much. And are saddened that we have to meet this way, and saddened that about what has brought you here today. I want to recognize also in the gallery the Washington County House delegation who are here, including delegates Baker, Grossman, and Weibel, who are there in the second row, and of course Delegate Valentine, who's a member of this committee, who co-sponsored this legislation along with me. Is there anyone who has any questions for this panel? Seeing none, we thank you both very, very much for coming before us today.
Thank you. Thank you, everyone.
We're now going to go to a panel including Chief Justice Fader, Chief Judge Bradar, and Judge Salas, who is coming to us virtually, I think.
She is. And I know she was in the waiting room. Is she?
She's here.
She's here. Great.
So a little bit different than our usual rules. It's a very difficult topic, and so I'm trying to give a little more leeway here. We are going to have a clock for 15 minutes. And as we're sensitive to everybody's time and trying to make sure that we get to hear from everyone. And I'm sure that there will be questions that come up next. All right. So with that, the Chief Justice, please.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. Thank you for this opportunity to testify here today in support of the Judge Andrew F. Wilkinson Judicial Security Act. Thank you also for taking this bill up expeditiously at this time. I am honored to be joined here today by Mrs. Wilkinson, who you just heard from, the wife of the late Judge Andrew F. Wilkinson, and here at my right by Chief Judge James K. Bradar of the United States District Court for the District of Maryland. And I'm also honored to be joined virtually by Judge Esther Salas of the United States District Court for the District of New Jersey. Also present here today are leadership from around the judiciary, including Judge E. Gregory Wells of the Appellate Court of Maryland, Judge Audrey Carrion, Chief Chair of the Conference of Circuit Court Judges and Administrative Judge for the Circuit Court for Baltimore City, Chief Judge John P. Morrissey of the District Court of Maryland, Judge Brett R. Wilson, Administrative Judge of the Circuit Court for Washington County, and Judy Roop, our State Court Administrator. The reason we are here is not a pleasant one. We're not here for grace or favors. And we are not here because judicial officers are more deserving of protection than anyone else. They're not. We are here because judicial officers whose positions represent the very embodiment of our government's commitment to the rule of law are in real danger, as are their families, from the ease of access to personally identifiable information from publicly available sources, especially on the internet. This is not a new problem, nor is it a theoretical problem, as we unfortunately know all too well. You have already heard about one and will hear about another incident of violence targeted against judicial officers. In one, Judge Drew Wilkinson was murdered last October after he did exactly what I'm sure every member of this committee thought was his job to do. He removed custody from a father who he concluded was a danger to his children. Judge Wilkinson followed the law and he protected those children. But because the murderer was able to find out where Judge Wilkinson lived, Judge Wilkinson paid for his life, with his life, for doing his job. Judges and magistrates across the state of Maryland have to make exactly that same decision many times every day. They deserve to do it without fear of paying the same price that Judge Wilkinson paid and that his family continues to pay. You'll also hear soon from Judge Salas, whose son Daniel was murdered and whose husband Mark was shot by a man who found his way to her house to exact his rage because she did her job. And apparently because he didn't like that someone like her was in a position to do that job. Judges, magistrates, and commissioners across the state have to make difficult decisions about people's liberty and rights every day. They deserve to do it without fear that their family members will pay the same price that Judge Salas's son paid and that Judge Salas and her husband continue to pay every day. The Judge Andrew F. Wilkinson Judicial Security Act is a limited bill intended to protect judicial officers and their families by making it harder for those who would take vengeance against the judicial officers for their decisions to find them where they are most vulnerable. It has three primary components. First, the bill identifies specific types of personally identifiable information that is protected from disclosure on the internet by private companies and by government entities. This includes home addresses and previously unpublished home telephone numbers. It also includes other sensitive information that could lead someone to the judicial officers or their family members, such as their license plate and social security numbers and where their children go to school. The act requires the removal of that information from the internet upon request. If the entity refuses, it allows a lawsuit to compel that to happen, and for private entities, damages. I note that the definition of personally identifiable information has two important carve-outs. One is for information the individual has previously made public or was made public with their consent. And the second is for information that is a matter of public concern. The types of information that are covered by this law will rarely be matters of public concern, but where they aren't protected and can be disclosed. There is also a provision for criminal penalties where someone posts protected information knowing that serious harm is likely to follow and where criminal acts are undertaken as a result. Second, the bill creates an address confidentiality program where concerns require greater protection than removal from the internet. This provision allows for covered individuals to use an alternate address in other records, including paper records. An individual with a legitimate business need can still get access to that information, such as for title research purposes, for example, as can individuals pursuing matters of public concern. In those situations, notice would be provided to the judicial officer, so at least they could be alerted. Third, the bill attempts to address different, but no less important safety concerns by creating a task force to study specific safety issues that many of our courthouses have, especially our circuit courthouses. Unlike the district court and the appellate courts, our circuit courts are not part of a unified court system. As a result, security in those courts is provided not by the judiciary, but by 24 different sheriff's offices. And budgets for security and related building issues are provided not by the judiciary, but by 24 different local legislative bodies. The result of that, combined with the ongoing difficulties in hiring law enforcement personnel across the state and the country, have been gaps in security. I do not mean to suggest that any security personnel are not doing their best. There are many individuals who provide outstanding service to protect our courthouses and our court personnel, and we are deeply appreciative of that. However, in some of our large jurisdictions, just by way of example, there's not enough security to have officers in the courtrooms other than in criminal cases. Guidance coming from the National Center for State Courts relating to judicial security tells judicial officers not to go into their courtroom unless there's a court security officer present. And yet Maryland judicial officers do so in some of our largest jurisdictions and in many of our most contentious cases every single day. There's also an absence of secured parking for many judicial officers and a lack of security getting to unsecured parking or from it to the courthouses in many of our courthouses. In Baltimore City, for example, more than a third of active judges park in public areas and walk by themselves to and from the courthouse, past the same people who will be or were before them in court that day, or the family members of those people. And in some jurisdictions, judges walk in and out the front door of the courthouse and park on the street. This bill would create a broad task force to study standards for those issues and to recommend legislation to address them in consideration in time for next year's legislative session. I'll note that I know that there's going to be testimony today from the Maryland State Bar Association and from the Public Defender's Office asking to be added as members of that task force, and we do treat those as friendly amendments and would be supportive of that. Attacks on judicial officers are increasing. The dramatic rise in verbal attacks on judges in public discourse, especially at the national level, has consequences for the physical safety of judges and their families. Threats to judges in Maryland have increased since the assassination of Judge Wilkinson. During the week-long educational course for new judges that we hold each year, which we affectionately refer to as Baby Judge School, I tell our new judges that the rule of law protects each and every citizen in the state of Maryland. And then I tell them that they now protect the rule of law. The people of the Maryland judiciary and our federal judicial colleagues in Maryland stand up for the people of this state every day. They should be able to do so without unnecessary and unproductive risk to themselves and their families. This bill is intended to help further that goal. I very much appreciate your consideration of this very important legislation. I look forward to your questions. And I'll turn it over now to Chief Judge Berdar.
Chair Clippinger, Chair Clippinger, members of the committee. Good afternoon. My name is James K. Berdar, and I serve as the Chief Judge of the United States District Court for the District of Maryland. I've been a federal judicial officer since 1998. I appear today on behalf of all of my colleagues serving as United States Circuit Judges, United States District Judges, U.S. Magistrate Judges, and U.S. Bankruptcy Judges here in the state of Maryland. Altogether, there are 33 of us. Legislators such as yourselves, before all others, certainly understand that the United States is a nation of laws. It's the rule of law that ensures that the public is safe, that commerce can efficiently and reliably occur, and that the rights and liberties of all are respected and protected. And of course, it is judges who enforce the rule of law. Accordingly, if judges are not safe, then the rule of law is not safe. And there is ample evidence that judges increasingly are not safe. Apart from the horrible attacks visited upon the Wilkinson and Salas families, with which we're all so terribly familiar, the United States Marshal Service reports that they investigated over 4,500 threats and inappropriate communications made against federal judicial officials during 2021, the last year for which they have data. A significant number of those were against judges right here in Maryland. Every time a case proceeds to a hearing or a trial before a judge, somebody loses. While the vast majority of citizens who lose their cases in court accept that outcome and move on with their lives, an ever-growing segment does not. And some portion of that segment descends into the business of planning reprisals against the judicial officers that they blame for their lack of success. This phenomenon is growing. My colleagues and I who serve in the federal judiciary in Maryland now come before you and urge you to pass the Judge Andrew F. Wilkinson Judicial Security Act. As you may be aware, federal judges already enjoy some protection of their personal identifying information as a result of federal legislation. But the federal law only protects judges with respect to their information that is stored or traded by commercial entities. There's no protection in federal law for judges' personal and private information that is stored in governmental repositories. But the bill that you have under consideration, if passed, would fill this critical gap in our lines of defense. The legislation before you would protect judges' most sensitive personal information, now stored openly by state government, including our deeds and land records that show where we live. We live in a time when two phenomena are intersecting. First, an increasing disposition to harm judicial officers when they rule against litigants. And second, a time when personal information, such as home addresses, can be quickly acquired with just a few clicks on a computer. If you enact the Judge Wilkinson judicial security legislation, you will not only be acting to support and protect your colleagues in the judicial branch of government, but you will also be acting to ensure that this remains a state and nation governed by the rule of law. The stakes are no less than this. Like the Chief Justice, I'd be happy to attempt to answer your questions. Thank you for hearing me.
Judge Salas, we'd be happy to hear from you, and we will go a little bit over the clock here. So Judge Salas, please.
Yes, good afternoon. I'd like to, before saying anything, thank the Maryland House of Delegates Judicial Committee for hearing me today. Despite the passage of time, it's been over 3 years since my only child was viciously killed in the foyer of our home. I can tell you that the pain is still as profound for my husband and for me. Without taking too much time, I want to just bring you back to that day, July 19, 2020. We had just finished celebrating Danny's birthday. It was a weekend celebration of his birthday. He had just turned 20. And him and I were in the basement talking, and the doorbell rang. And I can remember my son's face changing from calm and serene to concern. And all I can tell you is that, you know, my beautiful boy bolted up those stairs, and within a matter of seconds, I heard a sound that sounded like mini bombs going off. And I screamed, "What is happening?" And I ran upstairs, and there was my Daniel laying on the floor of the foyer. And my husband had crawled to the porch. He had been shot 3 times. Daniel sustained one bullet that hit his center of his chest, pretty much killing him instantly. And Mark had been shot 3 times. And, you know, I'm lucky to have him here today, but we almost lost him 3 times. And as we move forward, like the Wilkinson's family, I say move forward because you never can move on from what's happened to us. But we can move forward because we know that our loved ones, Daniel, Judge Wilkinson, they are counting on us to do what we need to do to try to impress upon members of the legislature that protections need to be implemented to protect all judges, all judges. The Daniel Anderl Judicial Security Act protects federal judges, but 30,000 judges across this great nation are really unprotected. And in Maryland, the judiciary, the state, local judges need protections as well. We need to be proactive. I did not see it coming. There were no red flags. There was nothing I could have done. Believe me, I've thought about it. And I know that Judge Wilkinson didn't see it coming. And, you know, and his family didn't see it coming. That's why we must be proactive and shield judges' personally identifiable information. It can be done. In New Jersey, we did it 4.5 months after the brutal attack. And there are ways of implementing these protections. And there are ways of ensuring that there is a balance between obviously the public's right to know and complete transparency, and yet making sure that a life isn't lost. You know, I can't tell you what it's been like for me. And I'm certainly sending my love and prayers to the Wilkinson family, who I know are there right now. And the only thing I can say is that it takes bravery and courage to do the right thing. And I am begging the Maryland legislature to do the right thing and pass House Bill 664. You know, as far as I'm concerned, the fact that you're hearing this now means that you are taking it seriously. And I can tell you on behalf of Daniel and on behalf of Judge Wilkinson, we thank you for taking this seriously. And we hope that indeed there can be the swift passage of this much needed legislation. Thank you so much for your time.
Are there questions for this panel? All right. Thank you, all three of you, very, very much for speaking with us today.
Thank you. Thank you.
The other people we have signed up to testify on this bill include Judge Fullerton, Jason Deloach, and Steve Kroll. Am I correct in that? Those are the other three. Anyone else? Those are the three we have signed up here. All right. We will hear from these three people. Members of the committee should be aware we're also going to go back to House Bill 315 because Judge Morrissey is here with us and he can answer questions on that bill after this is done. With that, we'll begin with Mr. Kroll, please.
Members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator and Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases for 39 years. Sadly, when I became the State's Attorney Coordinator, one of the things they gave me as an assignment was to prosecute judges who have been threatened. So since my term as State's Attorney Coordinator, I probably prosecuted more judges who have been threatened than anyone else. Let me rest assured and take this time to say this is a real threat, a real threat. Each of the cases I've gotten is a real threat to each one of those judges. And I ask you on behalf of the Wilkinson family, the Maryland State's Attorneys Association, and joining with the public defenders in the bench to pass this bill. It is that important. There are too many cases that I get, and quite candidly, I don't enjoy doing them. Thank you very much.
Thank you, Mr. Chair. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Jason Deloach, and I am the president of the Maryland State Bar Association, where we represent thousands of legal professionals across the state and serve as the voice of the profession. I am testifying today in strong support of House Bill 664. The issue of enhanced judicial and attorney security is paramount to our profession, as many of our members regularly travel in and out of courts and face threats and acts of violence and escalating scale, most recently with what we know with the tragic death of Judge Wilkinson. Judges and attorneys who regularly engage in high conflict matters, such as criminal and family law cases, are at great risk of physical harm and threats. Practitioners have shared some of their experiences. Surveillance and stalking by case parties to their offices and outside their homes, not having any security in courtrooms, as Justice Fader indicated, and having to change phone numbers, email addresses, and upgrading security measures in response to threats of violence, and having to request security after cases to get to and from the courthouse. The judiciary serves a vital function of upholding the rule of law and serving as a pillar of our democracy and freedom. While other government and public officials may also face these threats of violence and physical harm, the judiciary deserves the specific protection in this bill in order to preserve judicial integrity, permitting judges to make impartial decisions without fear of violence, threats, and physical harm. As Justice Fader indicated, the MSBA strongly endorses the establishment of the task force, but we would like a friendly amendment to join that task force. We think it's very important that we have a voice that will be conveyed from our members to make sure that everyone and our judges are safe. And I want to close by saying this. Judge Wilkinson died in his driveway in front of his family. It's not enough to name a courthouse after him. That's a great honor. It's not enough to put a plaque on the wall. That's not going to make our judiciary safer. We need substantive change. We had the opportunity last year and the bill did not pass. We did not have a Maryland example. And we just heard from Judge Salas, they had one in her state. You didn't have it in April of last year. You have it now. It was foreseeable back then that this could happen. And it's foreseeable as we're sitting here today with a tragic example. On behalf of our members of the MSBA, we urge you, give a favorable report and make sure that this bill passes this year. We're open to any questions.
Good afternoon, Mr. Chair, members of the committee. My name is Kim Fullerton. I am a legislative liaison for the MSBA and a professor at the University of Maryland School of Law. I also facilitate international delegations for the education of judges and legal scholars. Attacks on the judiciary is a global problem. The DOJ has noticed that threats to judges have increased dramatically over the past few years. We must acknowledge the gravity of this threat. It is an immediate and specific danger that destabilizes our democracy and undermines the public faith in the court system. Leaders in government are being targeted and assassinated because of their public service. That is a travesty. That is abhorrent to the rule of law. It is abhorrent to our Constitution. We have a duty here. We have a duty to protect judges from this known threat. We need them to be free from pressure and influence. We need people to feel confident that judges have protections in place so that they can make impartial decisions in cases. We need people to know that their cases will be decided according to the law and according to the facts. We must accept this duty. We need to secure our government from this recognized threat. We have to establish an effective protocol. We don't have one in place. We have to protect the third branch of government, and this is the bill that will do it. Thank you.
Are there any questions for this panel? Seeing none, we very much appreciate the testimony. I think the lack of questions, I hope people don't read into it one way or the other. I think that the committee understands the gravity of the issue and understands how challenging this has been, and also which is to be respectful to the family who's here with us today. So there may be questions that we have, and we know who to call, and we know how to get a hold of you. Sometimes you regret that, sometimes when we call. But having said that, if we have questions, I'm sure that we will call and we will take up this legislation expeditiously. Seeing no further questions, also recognizing the minority leader in the back who's from Western Maryland. Seeing no questions, that concludes the testimony on House Bill 664. We're going to ask Judge Morrissey to stay now on House Bill 315. Give a moment for people to take a step out. Going to send the vice chair back up there. House Bill 315 was heard earlier today. It was the vice chair's bill. The only other witness for the legislation was Judge Morrissey, who was across the street during that time. And there were some questions that I think members of the committee had for Judge Morrissey. And if this isn't too much whiplash for you, if you have any remarks you'd like to make on House Bill 315, we'd be happy to hear from you.
Thank you, Mr. Chairman and Vice Chair and members of the committee. And this is the first time I've appeared in front of the committee this year. So it's nice to be back and thank you for this time. This is an easy one. We would offer, the judiciary would offer its support and support a friendly amendment that would remove in the first page, third line through fourth, the Department of State Police, and instead substitute in that the Administrative Office of the Courts. As a prior member of the State Commission on Criminal Sentencing Policy, I know that they don't have the data. The state police reached out to us and indicated that they would have difficulty in accomplishing that. We asked our IT department to give us a level of effort on what this would require, and pleasantly they came back with a minimal level. So rather than playing whack-a-mole, we would offer to take the position on this and provide this report.
Questions? Okay. Then that's fine. That then really concludes the testimony on House Bill 315.
And thank you. I
with that,
apologize for being late.
Not well, no, not at all, especially not today, because you've been over there as the Senate heard that bill as well. So thank you very much. Now that concludes the testimony for the House Judiciary Committee. We will be back at 1 o'clock tomorrow. Members of the committee should be aware that it is possible that next Thursday on the 8th of February that we will be hearing legislation and maybe starting early, maybe as early as noon. So you will want to keep that. I would ask you to keep that extra hour there, please. We may have to start just a little earlier for witness availability on that day. So more information about that next week. Thank you all.